It is about 7:03 p.m. Central Standard Time. Today is Monday, November 22nd, 2021. And my name is Richard Wright, as you already know, and I'm your instructor for the next, I guess now roughly 4 more weeks, or 3 more weeks. And this is week number three, week number three. And just a few comments. Number one, I do remind students that if you have an issue and you need to reach me, you can send an email, but that's snail. Best way to reach me is text me or call me. And I already shared during week one that you can text me, call me any hour of the day except the 25th hour of the day. And again, that's on the syllabus. Some people forget about week one. You can call me, text me, or email me any hour of the day except the 25th hour of the day. I respond pretty fast to students. One of the things I don't like about the email system in this particular course mail is that messages like, okay, I'll click on this and show you what I mean. And you'll see, I'm gonna just click on it real quick. So if I go all the way down here, these are all messages that I sent or responded to a student and stuff like that. So it's hard to sometimes find all those messages. But anyway, the point of the matter is it's not as good as the old system. However, though, texting and emailing me texting me and calling me any hour of the day, except the 25th hour of the day, is the way to reach me. I don't have many students who say to me that I don't respond to them pretty fast because I do that. But you got to make sure that I know uh, that something takes place. And so if I have an issue that I think is important, I think that it would probably behoove me to reach to the professor the fastest way. As soon as you send it by uh, telephone, it will show up. It will show up right here on this phone, and I will get it. So let's take a look at the calendar. And the reason why I go over the calendar every week is because inevitably I will have 1 to 2 students every term that don't know what the due dates are. So I apologize to those of you who are on top of it, but this is our live lecture. Initial post is due tomorrow. Your reply post is due Saturday. And then, of course, Sunday, your live classroom phrase or written assignment is due. You can get your live classroom phrase out of the way today if you are in class, and I give it to you anyway. Then I like to have fun with my students to see if you pay attention to the lecture itself and see if you can figure out what the key phrase is. And sometimes students are pretty good at it. And then the last thing I'm going to say is this. The 17th is it. If you submit an assignment at 12 o'clock, it's going to show the 18th, and it's not going to be happening. I'm not going to grade it. I can't calculate it. By school rules, the course ends. There's only one way to do that, and if you follow the incomplete process, and that's found again, going back to the syllabus, and you got to do that appropriately. And I'm the one who determines whether or not I grant that. And I'm pretty good at doing that. But that's it. So if you think, oh, my posts are due the 18th and the written assignments 19th, it's not going to happen. It is not going to happen. I got 2 students that happened to term 1 rather. This is term 2. One of them was actually in this class, this course, and they didn't follow it. They want to know why their grade was lower. Final grade is because I couldn't calculate the assignment that was due. That was actually this written assignment, the same one that you guys are going to have. Okay, so let's stay on top of stuff. Let's come on. Let's do this. I pride myself in making sure that I equip my students to operate from excellence. I have students occasionally say I'm accustomed to the dean's list and honor roll. I say then that means you should be able easily to follow the requirements of the assignments. Okay, very important, very, very, very important to me and should be important to you. All right. Let's look at the week 3 announcement. The 4th Amendment and government authority. And if you don't know by now what the 4th Amendment is, it's search and seizure. And chapter 9, I gave you the PowerPoints for your studying. And the criminal justice system, Terry versus Ohio, 50 years later, you should know that the Terry versus Ohio case is known also as the famous stop and frisk case. And then you're going to look at these items for each of these, and we're going to go over some of these tonight. So the lecture is now your discussion assignment, reasonable suspicion, and that is due tomorrow night initial post, and then Saturday reply post. Finally, be sure to complete the written assignment, search warrant exceptions that we'll do, and then your key phrase, and then my motto, just continue to be strong and finish strong, and apply the motto, adversity is the springboard to success. All right. So let's get into it. I always like to start out by letting you know the topic of the 4th Amendment and government authority, and we're going to go over the written assignment first. That is the very first thing that I want to spend some time on. And you have these 5 scenarios, good people. 5 scenarios. You're going to read each one and discuss the exception to the search warrant requirement. I did give you some cases that can help you deal with this. Did you get those that I sent you in the email? Just type in yes in the chat box and I'll see it, or no. Did you get it? Let's see. Okay, good. I don't know why I can't see the chat box on this page, but anyway, oh, I know why, because I'm looking at the assignment right now. So anyway, they should help you. And actually, to be honest with you, give you a little tip. Some of these scenarios are right out of those cases. So in a 3 to 4 page, 3 to 4, not 2.5, not 2 3/4, please, double space. discuss the applicable exception to the search warrant request. If no valid exception applies, explain why there is not one. Support it with appropriate case law. I want cases in here. I want to see citations appropriately for the cases. You know, I've already stated over and over, give me the official court case citation, because these are United States Supreme Court cases. And I want you to be in the habit of doing that because of the fact that it will help you in the long run. Those of you who are in this course who have been paralegals know exactly why I said this. Cite credible sources with APA formatted, that is for sources that you discover, and specifically the court case. Don't just tell me Marbury versus Madison and then that's it. No, tell me Marbury versus Madison and whatever the appropriate citation is. If you don't see it, which you will, then you can easily find it by Googling the case name, and it will lead you to it. All right. But I got to have a reference page. I got to have a cover page. I got to have it double spaces, and I got to have credible sources. So guess what? If you answer scene number 1 and you don't have a credible source, you're going to lose points. If you don't have a case cited, you're going to lose points. Very important. And then it is a Word document, and you should specifically do so. I do run all your papers through Grammarly, which hasn't been really a major problem here. So now let's go to the grading rubric, which if I were you, I would take my grading rubric and I would look at this column. I told you, ignore these columns. Unfortunately, students either don't listen to me in the lecture and they try to do the assignments without listening to the lecture and then just go through it real quick for the key word or phrase, and they miss something that could help them exceptionally well to get honor roll and Dean's List. I said it the day one. I says, my goal is to work with honor roll and Dean's List students. And if you follow the process that I give, it will keep you on track with that. I don't know, some people told me to get on the honor roll and Dean's List without doing APA. I don't know how, because the fact that that's one of the important rules of the school. And I don't compromise with the rules of the school. So anyway, for each scenario, you're going to provide an outstanding discussion of the exception with comprehensive details on whether there is no valid exception that may apply, and thoroughly support with appropriate case law. Let me show you what happens if you don't have case law. You can't get in this column. You can't get in this column. You get in that column. You gotta do it. That's why I said, don't even read this. Read this. It's like I was trying to tell a student earlier today, and we were having a discussion, former student of mine, and we were just having a general discussion about the way to success is follow the instructions and directions that are laid out by the author of the process at which you're operating. I'm not the direct author, but I do follow the materials. I don't write these courses, but I like the way that they did constitutional law, especially. So, because they make you concentrate on case law, which is so important in terms of dealing with search warrant exceptions, which is why I gave you those cases. All right, but there are others too. So anyway, scenario 1, same thing all the way through, all 5 scenarios, same thing. So you don't want to have any of these over here. You want to have them all over here. Again, it reminds you about credible sources, which we've already talked about, with no errors. APA formatted, what we just talked about. And then it must satisfy the requirement of 3 pages minimum. If you go above 4 pages, I don't care. That's good. But if you go beyond 3, I mean under 3, that's not good, because you could have everything really good up here. But if I get over here and I see that it's not 3 pages, and I'm not counting the cover page, and I'm not counting the reference page, it says professional language is not used in 3 to 4 pages or does not meet the minimum 3-page requirement. Okay, with numerous errors that detract from, okay. But the point of the matter is that the key thing in this is making sure that you get the 3 pages minimum, double space. And it's easier to do that. If you had to do 3 pages single space, that'd be a lot. But 3 pages double space, I would rather do 3-page double space. And again, I operate on mastery. That's how I teach. Sometimes I sound like I'm lecturing, because I am lecturing. But the point of the matter is that I just want you to understand my approach. And most students appreciate the fact that I get them to develop good habits that carry over in their professional careers. Because guess who I get calls from? I got one right now from a former student to write a letter of recommendation. I will do that, to go to law school, and that's what they want to do. And I've had students that want to go to police departments. I've helped them do that. But you got to do this, guys, please. I'm almost like on bended knees begging you to do this, because it's for your good. All right. Any questions about the written assignment? You can type it in the chat box. Okay, let me see. I don't know why I can't see the chat box on my oh, my bad. I'm so sorry. That's why. Okay. I hate this new thing they got here. Here's what I got to do. I got to come back and hit share, and then hit this, and then I got to hit a second share. Now you see it. Okay. That is on me. Okay. Okay. But I'm telling you, they made so many changes to this system. We didn't have this before. So let me just backtrack. All right. Forgive me. Thank you for letting me know that. Because, oh God, anyway, that's why I didn't see your name or either my face. So, okay. All right, Blackboard, thank you again for doing this to me. So anyway, each of these scenarios, each of these 5 scenarios in a 3 to 4 page paper, discuss the applicable exceptions to the search warrant requirement. And if one doesn't apply, why not? Cite credible sources in APA format, include a reference page and a cover page. Use correct grammar and spelling. All right. So now let's go back to, now remember, each of these scenarios, you must, okay, you'll see it in a minute. You'll see now. Thank you, Valerie. I appreciate that. Mastery. This is a column. I don't even want you to, I wish I could erase this, but I can't. And the reason why is because if not, then the student won't totally understand why they didn't get this. But the answer to the question is very simple. What comments is it that I need to make? You didn't provide case law. Provide a case law with the official court citation. All right. And that's for all 5 scenarios. If you don't, notice what it says. If you're missing it in either one, it's going to come over and you're going to lose 50% of the points. So rather than get a 18, you're going to get a 9. Nobody wants a 9 when they should be getting 18. You agree? I know. I already know. You don't have to say anything. But the point of the matter is that that's the key. The key is stay in this column. Stay in the column. And then credible sources in APA format, including reference page with no errors. And then it requires 3 pages. If you don't get 3, you can have everything else up here. And then if I see 2.5, 2 3/4, I got to put you over here. Okay. All right. Don't look at it from a standpoint that it's 5% of the grade, because that could make a difference in an A and a B. All right. Now that I've said all of that, and thank you again, I really appreciate it. I'm gonna have to keep reminding myself that they got this new setup, but anyway, okay. You good? Any questions about the assignment? Yeah, I'm good too. Thank you. All right. That's why I appreciate my students. Even us professors recognize, we're not all bitey, all knowing. Even though my last name is Wright, I'm not always right. Okay, that's a joke. My wife reminds me of that all the time, but I told her, you got the same last name though. So anyway. All right. So let's look at the discussion assignment. Reasonable suspicion. Um, and its application to suspicious people and vehicles. So you're going to use this scenario. And then you're going to do your initial post. Uh, and you're going to initially explain why you are able to stop John based on constitutional law. One stop, discuss what you do next. Why may you be able to frisk the interior of the vehicle? And then in your reply post to another student. Okay. Did you like that last one last week with the head in the refrigerator? Did you find that pretty interesting? Yeah, yeah. Every week, every time I get ready to do that one, I love that one. But I can imagine. But see, remember something. Oh, okay. Did he think that the police officer was out of line? Oh, okay. Oh, I've been a lawyer since 1978. Yeah. Okay. Good. Good. That's because you're smart and you knew that was it didn't fit on any exceptions. Somebody said, well, "What if?" And this is what a student said to me. What if the refrigerator had a glass door? That would change the whole scenario. But it didn't say that. So here's what we try to explain to students, and this is what we had to learn when we were in law school. You work with the facts that are given because they have reasons why they specifically do that. Most refrigerators don't have glass doors. Most don't. I mean, you go to a store and stuff like that. That's a different kind of refrigerator. I don't know. I have seen some inevitable discovery. No, no, no. That wouldn't apply at all because how? Why would they? If they'd have got a warrant and done it, but if you look at inevitable discovery, that means that it would have been found anyway. The only way this could have been found is if you told them or gave him authority to go into his refrigerator. Okay, go and get a warrant and then come back. Yeah. But remember what this is? This was about an exception to not getting a warrant. Yeah, you're right. You're right. So I guess if they discussed it with him and left to go get a warrant, what do you think would happen to the head in the refrigerator? Yeah, it would disappear because he'd move it. Maybe he'd eat it. I don't know. So um, cook it up and something. You ever heard? Yeah, okay. Here we go. I was just getting ready to go there. Yeah, Jeffrey Dahmer, but very much a carnivore. Uh, but that's kind of like that's anyway. That's not. I don't know. Not my type. Not my type of meat. Okay. So, but yeah, so all valid points. But you got to remember the whole exercise, and the point was, did he violate his constitutional rights? Did he give consent to search that refrigerator? And the answer is no, absolutely not. Therefore, he could be awed like, oh, but what he could have done was close it and never um, arrested him, and then maybe had a conversation with him later, and try to get around like what you just said, Valerie. Somehow or another, says, you know, um, um, can I get a drink of water? And then and then you follow him back that way. Then he opens the refrigerator. You might probably what he would do is not give you a drink of water from there. He'd give you a drink of water from the faucet, but or juice or something like that. Says no, and says, don't you really want to give me a juice? Yeah, absolutely. You're right. You're right. But the point of the matter is that's why we have in this Constitution the unreasonable search and seizure as a violation. And that was a clear violation because it didn't fit into any of the exceptions. But you can try to fit it into that one. So, all right. But that was that's my favorite discussion forum in this week in this course. My favorite one. Okay. So then we have your live classroom submission, which you'll put your key phrase in here. If you're here like tonight, you can do that. And then this is the link. So, okay, let me see what your question is. I got to go back and pull the chat up. Here we go, where it says more. Okay, let me see what you asked. I thought it was a homicide situation, then different rules apply. No, no. You don't toss out the constitutional rights if it's a homicide. Mm-mm. Same rules. There's not a set of rules for robbers and for people who commit murders or killings. No, it's the same. The constitutional rights afforded that you have to get a warrant unless it falls into one of the exceptions applies whether or not it's a homicide. So I don't know where you got that one from, but the answer is no. Absolutely, positively no. I think you're probably thinking in terms of exigent circumstances, right? Is that kind of like what you're thinking of? Let's see what you said. No, I don't know where you read that one from. Yeah, exigent circumstances. Sometimes people think because no, what exigent circumstances involves is if, for example, uh, I'm I'm witnessing that somebody's life is in danger, or either I'm chasing an individual and they run into the house, and I see them put something in the refrigerator. Okay, and then I chase them in, and then I open up the refrigerator. Then that's different. That's where you get to that. But it has to be based on exigent, and the reason why it's exigent is because it's based upon the moment that is there. Um, some people try to apply that because okay, the person could move it, but the point of the matter is that it would be in his best interest never to move that because they immediately placed him under arrest. They got overzealous. That's what it was, and I said that in my responses to a few students posts. So nope. So all right, but that is a fair question. Um, there are no such things as questions that are not fair. All right, so let's get to where we are here. Okay, so we're going to talk about probable cause and reasonable suspicion first. So what is probable cause? The word probable explains it basically. It is a high standard, and the Fourth Amendment makes it quite clear that it says that no warrants shall issue. In other words, you can't even get a warrant but upon probable cause. And then you have to go to a magistrate or judge and request that warrant. Probable cause was not defined in the Constitution, but it's applied on a case-by-case basis, and throughout the years, and we're going to get to that in just a few seconds. So just remember, as it says here, most arrests, searches, and seizures are conducted without a warrant. Most are without a warrant, but are based upon probable cause or supported by a Fourth Amendment exception. And then we're going to discuss some of those exceptions, which you already should know about from previous session that we did. All right, so we're going to deal with what probable cause is first, and then we're going to deal with what reasonable suspicion is. So they give some cases here. The one that I like is the one I'm most familiar with, and that's the Gates case, because it was while I was practicing, that in dealing with probable cause, as the name implies, we deal with probabilities. That's what I was pointing out to you. They're not technical, they're factual and practical considerations of everyday life on which reasonable and prudent people, not legal technicians, act. So it's a common sense thing. That's kind of basically what it really is. And I remember that studying that when I was practicing law a few years after coming out in '78 when the Gates case came down. And I remember this language here saying that it deals with probabilities. And that was what I was starting to say a few minutes ago. Probable, more likely than not that the person did it. And it consists of, as it says, a bunch of facts and prudence and reasonable conclusions available at that time. It says probable cause is the level of proof necessary for law enforcement officers to make an arrest or support an arrest or search warrant. So law officers are often tasked with determining if probable cause exists to believe a crime was committed and then tie it to that person. That's how they get their warrant and arrest warrant for individuals many times. I didn't deal with getting those, but I did have those presented with warrants because I was a defense attorney in most cases. I was a prosecutor, but I was local prosecutor, municipal stuff, and we didn't deal with the felony cases or the misdemeanor cases. Okay, so the key thing is that you got to remember it's just basic common sense. Okay, if probable cause doesn't exist, then we have one other one that we'll come to in just a minute. All right. Any questions about probable cause? Okay. Now, let's talk about reasonable suspicion. The leading case that established reasonable suspicion was what we call the Terry stop, Terry versus Ohio. And remember, once again, if you cite these cases, you're going to cite the whole thing, but you'll see it in here too. And one of the things that I take issue with most of the time when they put these scenarios together is they don't give you the full court citation in the body. I require it in the body to get you into the habit. And remember, you only have to say that once. If you do it afterwards, it's okay. But the very first time that you cite the case, you want to do it. And I'm not talking about the caption. I'm talking about in the body of the paper. And so anyway, it describes what happened in Terry versus Ohio. And I'm not going to read all of this. But the bottom line is that there was a reasonable belief based upon the circumstances observed by the law enforcement officer that this person was acting, quote, suspicious. That's the way I would put it. And so the detective, it says, grab McFadden. Detective McFadden grabbed Terry, spun him around, patted his exterior, and felt a pistol and removed it. He also patted down Chilton's exterior clothing and found another revolver, also in an overcoat pocket. At no time did the detective reach into the pocket until the weapons were felt. That's a key point. Key point. And I'll tell you why in a minute. And so they were arrested and charged with carrying a concealed weapon. All right. So it came to the point that the whole argument of what we call stop and frisk became a standard. The appeals court agreed, but the Supreme Court for the state of Ohio denied the appeal. And the U.S. Supreme Court agreed to hear the case and affirm the lower court's ruling. And so the Terry case, as it says, established the well-known Terry stop that I mentioned earlier, which is an effective investigative tool and has been put in statutes in most jurisdictions. So it was an 8-1 decision written by Justice Earl Warren, who was one of the liberal justices. He was also involved in Miranda and some other cases as well, provided that law enforcement officers may be able to, and this is some language in here. I'm gonna read it for you because I want to read this one thing out. We say crime is afoot, and it doesn't mean your feet, but it says, and it came out of Justice Warren's words. It says, we merely hold today that where a police officer observes unusual conduct, which leads them to reasonably believe, to conclude in light of their experience that criminal activity may be afoot. In other words, when it says crime is afoot, it means it's actually taking place before them, and that the persons with whom you're dealing with may be armed and dangerous. So identifying yourself as a police officer, then you are allowed to pat the person down. And that's where I come to the important factor about why it was important for them to reach in after finding the weapon. The primary thing is to protect the officer. And by doing so, if they felt a bulky item like that, then that can take them to the next level. But if they did not, for example, if you pat somebody down and you and a bag or something is in the pocket. And you say, "What's that in that bag?" And the person says they're not going to answer the question. Then uh, you can't go in that pocket and check and see what's in that bag. If the person says they're not going to take it out, well, then the point of the matter is then you'd end up having to find some reason to arrest that person. Maybe you'll find a weapon on them or something like that. Then any evidence against that person that's taken in, like if a bag is found, may be seized. The stop is very temporary. It as it says, there's no specific amount of time, but again, the stop may last as long as it would reasonably take a law enforcement officer to determine if criminal activity was afoot, to make reasonable inquiries, like asking your name, stuff like that. There are statutes in Ohio that specifically require that, and an exterior pat down to ensure they're not harmed. Now, the Terry decision um, um, came to a head later in Rodriguez versus United States, where many states have adopted a 20-minute rule, where if a detained person is released, if probable cause is not developed within 20 minutes. So that's it. But the pat down, as it tells you once again, is to the outer area. And then since Terry, there have been other cases that extended to searching the motor vehicle, a brief look for weapons that are readily available in the area where the driver could have been in control of, and those kind of things. The famous Minnesota versus Dickerson, what we call the plain field exception. We always laugh. I say, I live in Plainfield. No, Plainfield I live in. But Plainfield, where it permits officers to pat down and remove suspected contraband. That's when it changed to that point. But before that, you couldn't do that. So it's important to know the difference. Any questions about either of these two? And incidentally, what they do here is that when they do give at the end, they give the full court citations at the end, except they don't do it in Michigan versus Long or in this one either. So you have to go and you have to look them up. Okay. Any questions? Okay. But it's interesting because it makes you stop and think. You say, so you're tying the hands of law enforcement officers. No. I represented some law enforcement officers, and I had Fourth Amendment search and seizure issues representing some of them. And we were able to suppress some things because the colleagues that arrested them or stopped them, they found things they went beyond the search. So the Terry search. So it comes in. The key thing that I want all you guys to remember is this, is that it has to be based upon an initial observation that crime is afoot, whether it's taking place in the presence of that officer or is about to take place, or the person looked very suspicious. Like for example, if you, 12 o'clock midnight and you driving by and you see a person peeping in the window and of a store, and they're walking back and forth and they're looking around. Would that raise a level of reasonable suspicion to the average officer? Yep, it sure would. And it would kick in the, because it wouldn't make sense to say, oh, we got to get a warrant first. How you gonna get a warrant first? You don't know the name of the person. You don't know anything. So you can't um, um, operate on that basis. All right. Fourth Amendment and warrant requirements. which kind of helps us a little bit more here in our next 10 minutes. So this just explains pretty much when we talked about probable cause, you have to get a warrant, an affidavit, and uh, and you learned about probable cause and how it works. And the warrant must be supported by the oath of the officer or affirmation that the person or place to be seized. And the Fourth Amendment makes it quite clear that the rights of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated. That's why the head in the refrigerator thing, it smacks dab of what this was designed to protect against. Okay. And so it shall not be violated. No warrants shall issue, but upon probable cause, with an oath and or affirmation describing the persons or the areas to be seized. So unreasonable is something that the judge determines whether or not it is. And if the officer wants to issue a warrant, they must complete an affidavit containing adequate facts to support the warrant. And then the judge reviews it, and if they agree, they issue it. All right. Very important. Very important. All right. And then this tells the requirement of warrants must specifically describe the place. For example, suppose detective desires to obtain a warrant in a burglary investigation. In that case, they have to identify the stolen property they are looking for. Okay. The make, model, color, serial numbers can also help satisfy that requirement, but they're not necessary. When seeking drugs, the illegal drugs must legal drugs must describe and cannot just state cocaine, heroin, or methamphetamine. Officer would have to describe what it looks like, such as a white fine powder or a rock consistent with cocaine. That would be better. So the key thing, and then dealing with the particular place, your 721 Main Street, you got to make sure that it's the right place. If it says 721 Main Street and that's an apartment complex, it's also probably going to require a unit number as well, those kinds of things. And so the key thing is that you want to make sure that it's narrow enough to let the judge know or the magistrate that you have an idea of what you're looking for and where you're looking for it. That's basically it. Once the items or persons to be seized have been described, the warrant must include an affidavit, and the affidavit lays out the facts to support probable cause. That's why reports and everything. Remember, I was talking about one of the transferable skills is written and oral communication. Remember, we talked about that week 1 and the importance of it. Remember that? Yeah. So this applies that, particularly the written aspects of it. I remember what we used to do, and it was kind of boring for me because I was already a lawyer, but I was working as a police officer in the town. I had been a defense lawyer and representing people and still did outside of that town. So we had to sit down and we had to write affidavits. Now it was cool for me too, from the standpoint that I had some experience doing that, which I could use later on in my defending individuals, but not in the town where I was a police officer. So it wasn't catch them and then defend them type deal. I couldn't do that. But they're written, as they say, in chronological order, and includes the content that would help a judge or magistrate to determine that there really is probable cause. Okay, and then this clicking on this link should let you see what a search warrant looks like. Let's test it and see. Okay, let's see what it's going to say, and it should pop up in a minute. Show you what. Okay, here we go. And this is an example of what they look like, so you can read it over yourself. Okay, and remember, this is the affidavit, an application, um, where the person says under oath that they believe these things are found where and what they're looking for. So you can see that as an example there of a search warrant. Okay. You said in one of your other classes, let me get that back. I think I know what you just said. Yeah. Yep. Yeah. I when I was doing a course that was called um, written and oral communication for law enforcement officers, that was an exercise that we used to do in that class. Now they do it in another class. So yeah, and that's the point, so that you'll understand. So all right, now a no-knock warrant or announcement that police are permitted to forcibly enter, but no-knock warrants are not good. They're bad. There was a recent incident that took place in the last year or two that everybody should be familiar with as to why no-knock warrants are going to be used by, and most departments are discouraging them and doing away with them. Do you know what case that is? Happened in Kentucky. Okay. No. What was the name of the lady who was killed? And there was a no-knock warrant involved. Remember? Okay. Um, I know her name, and as soon as I give it to you, you will you will know. Okay, give me a second. Oops, my fingers. Um, okay. Breonna Taylor. That refresh your memory? Remember that name, Breonna Taylor? Yeah, yeah, Breonna Taylor. I drew a blank on her name, but that's the reason why. And if you pay attention to most departments, and then that's also part of the legislation that that Congress is working on to try to um, do away with those, because there are more dangerous things that can happen to people in no-knock warrants. So they're kind of discouraged. Um, So the key thing is that um, if a policeman has to knock and announce, that's different. But a no knock warrant means that the person doesn't have to do anything at all. If there is no reply within the structure, police can then force entry, execute the search warrant. A no-knock warrant does not require a knock or announcement. And that's where we run into problems, like what happened with Breonna Taylor. Remember, the guy, the boyfriend, started firing because he didn't know who those people were. And so ultimately what they did was they began to bombard the place with um, um, bullets, and it killed Brianna and wounded her boyfriend. So anyway, that became one of controversy. So, all right. So you know about the reason why we discourage those, but Breonna Taylor case is the primary reason why we don't want those anymore. Okay. Warrant key terms. I'm just going to show you this and you can look at this on your own, but I'm just going to let you know it exists. These are flashcards, and you can go to these flashcards, unreasonable search and seizure. And then it explains that. You can go to the next card, affidavit, and explains that. So I'm not going to go over that with you, but that's where you can do a little exercise yourself to help you. And so finally, we get down to a few other things. Exceptions, I think we've already talked about that as well. But here are the exceptions laid out. Plain view, consent searches, automobile exception, search incident to a lawful arrest. Then there are probation or parole searches. People can search the garbage as well. So these are just some of the exceptions, but I also gave you a list like attenuation. You can look at those as well. And if you have any specific questions, consent is one of the areas that we've been talking about quite a bit. That was the one with the guy with the refrigerator and the head in the refrigerator, you know, and it has to be voluntary consent. And then automobile exceptions, because automobiles are mobile. Search incident to a lawful arrest. So then once the person is arrested, you can search the area and the immediate belongings and things like that. And then probation or parole searches are a little bit different there in terms of it. If you put something in the garbage, there is no reasonable expectation of privacy when you put out garbage. Throw it in the garbage. That's why you can put stuff on the curb and people grab it. Okay. And happens all the time. But there are a lot of cases. I'm reminded of a case when we were looking for some drugs and we had to look in the garbage cans. But one of the things that we had to be very careful for, that we had to look out for, was what? Did anybody know that would have been a danger to us in the garbage can? Yep, you got it already. You hit it right on the head. That is exactly correct. That is exactly. We had some special gloves that they gave us to wear so we could protect ourselves against it. They had like a steel lining inside to protect against that. So yeah, but that's one of the exceptions as well. And then these are some cases here included, but I gave you cases as well. Any question about Fourth Amendment exceptions before I leave and wrap up? Okay, because they're pretty clear. The common exceptions include the Terry, and then vehicle searches, consent searches, plain view, garbage, and probation, the ones that are in here. This is your knowledge check again, where you can study yourself and go over. And what is the level of proof needed for an arrest or search warrant? Yeah, yeah, it is. I laugh because some people get caught up in things like, okay, it's only two that you would even consider, probable cause or reasonable suspicion. But somebody put beyond a reasonable doubt. I said, that's the standard in the criminal case. Preponderance is the standard in civil cases. So you toss them two out right away. But to obtain a warrant, reasonable suspicion won't cut it. It has to be probable cause, and that's it. So, you know, um, and it explains it there. The last one I'll do is, although a maximum length of time has not been determined by the courts, blank minutes has been deemed reasonable in other cases. I told you one. That's right. There you go. 20 minutes. Yeah. So you can go over that and study that on your own. Okay. And then there's the survey, midterm survey that you can complete. Be aware that after we complete this week, assignments for weeks 1 to 3 that have not, I have not been turned in will not be accepted. Now, even if you turn them in, if you don't have a good reason why 1 and 2 are late, like some students do already, and they let me know, that's one of the key things. You know, don't feel bad when we get to week 4 and I say, I'm not accepting 1 to 3 anymore. Okay, you got to let me know. All right, that's why somebody comes in week 6 and says, I need to be able to pass this class, and crickets for me, because I'm just saying, and usually they don't say it to me on the phone. They send it in an email, and I respond back, call me, let's talk about it. They won't call me. Okay. So anyway, the key thing is, and it's only sensible what I do, why I do that, is because I don't want students, cramming is no good for you. It really isn't. It'll help you maybe pass the course, but isn't your goal to pick up knowledge that you gain each course that carries over, to put more tools in your arsenal as the professional you hope to become? Isn't that the way it should be? Yeah, you don't. You don't learn if you cram. That's exactly right. So anyway, I'm an anti-crammer. So anyway, I am going to end. Any questions? You got it already. How about taking a guess? Okay, I'll give you that one. I had reasonable suspicion or probable cause, whichever came first. So I'll go with Valerie called it. Valerie Olan, your classmate, everybody who didn't come tonight, she called it. It's probable cause. So if you didn't get it right, blame her. All right, yes, probable cause. That's a good one. But yeah, I only had that one or reasonable suspicion in mind. So excellent. Well, I'm done for the night. Um, yeah, big shoulders. All right. You should have a thick skin too, as well. But okay. Yeah, your boyfriend probably knows that one, right? He knows you have both of those, right? Okay. Well, I do want to take the time to wish each and every one of you a happy Thanksgiving. Um, I will not be grading papers on Thursday. There is an announcement that you probably have seen that said that for a few hours, Blackboard is going to be down on Thanksgiving Day. I said, I don't care. I told my dean, I said that my students shouldn't either. I said, Dave, we're going to be celebrating with family and friends. And then I'll be looking at, thank you. Yeah. My Black Friday shopping is online. I don't get out there. I've seen some real live um, terroristic activities at stampedes take place when they open the door. And beside these people, yeah, see, that's what I'm talking about. You see what I mean? Yeah, pushed over for a towel, Well, I remember years ago, I had my daughter, we were looking for, um, what was the name of those ugly looking dolls that they had birth certificates with them? Um, Cabbage Patch. I'll never forget that. They're grown now, but and they have real kids now. But looking for the Cabbage Patch dolls. Oh my God, that was horrendous, So, but then there are people now get in line to get the latest Xbox or whatever else they're gonna get. So, but anyway, no, I go online and do my shopping where, you know, and then we got some supply chain issues. You already know that for now with this pandemic and everything. So anybody enjoy. And then, like I said again, um, I will be grading papers on Wednesday and Friday. But Friday, of course, is when your assignments are completely graded. But I'll probably have yours graded in this class before that because it's only 9 of you guys in this class. So I'll probably have it before that. The other class has more students. So again, I wish you the best. Happy Thanksgiving. I'm going to be watching football for a while. I'll probably be crying because I have the Bears, and lately it's been a sad occasion for me. It's been a sad occasion to be watching my Northwestern Wildcats. Yeah, have a good evening. You hated yesterday. Are you a Bear fan? You're a Packer fan, right? Aren't you? No, you're a Packer fan. Who? Oh, Bears. Oh, okay. Yeah. Yeah, I couldn't. Yeah. Wasn't that ridiculous? You know what? I'm helping pack the coach's stuff right away. Get this dude out of town. Yeah. Get him out of town. And Nagy, he has to go. I mean, he they need that O line. I knew eventually that somebody was going to hurt Fields. And he's a good quarterback. But my God, if you're always on your butt trying to pass, on your back, and then, you're getting hit all the time, So he's a good scrambler, but my God, but anyway, that was sad. And then we lost Mac for the year. I mean, it's, Khalil's gone for the year. And I got my number 52 jersey and my number 1 jersey at home that I wear. So anyway, I'm with you in that also. And then, so the other thing I'm going to do is I already saw it, but we got people coming over. I check out if you had a chance King Richard. You know about King Richard? Has nothing to do with me. You know about the movie King Richard? It's about Venus and Serena Williams and how they arose to become top tennis players. It's their dad, Richard Williams, was their motivation. But it's out on HBO Cinemax and HBO Max, but it's also at the theaters too. It was a tearjerker for me to watch that. So, but yeah, King Richard, Will Smith plays the dad in that movie. So he's always a good actor. So okay, well, again, have a good time. Enjoy the turkey, the ham, and if you're a vegan, more power to you. More turkey and more ham for me. Okay, take care. I'll see you.